Welcome to Bcast, Benesch's business law videocast series. This is where we discuss the most topical legal and business issues. In this edition, we're going to be talking to Jeff Kosc, partner in Benesch's 3IP practice group. Today, host Rick Hepp is going to talk with Jeff about key concerns in cloud services agreements.
Hi, my name is Rick Hepp. I'm an attorney in the Employment and Labor Group. Today we're going to speak with Jeff Kosc about iCloud and cloud service agreements. Jeff, how are you today?
Doing great, thanks Rick.
Good. So, Jeff, can you tell me what is the biggest concern that clients have about cloud service agreements?
One of the most common problems that I run into with clients is a client coming to me after they've entered into an agreement for a long term and they have no way of getting out of the agreement, and they're running into problems with the vendor, or they want to simply change services, and they come to me, and many times it's after it just automatically renewed for another long-term period, and they say, how can I get out of this? And unfortunately they're committed for a long-term period. So one of the things we always make sure that we really look out for in cloud services relationships for clients is making sure that they have a way to address their business flexibility and make sure that they can get out of agreements either for convenience sake or even more importantly when the service just isn't working, that they have rights to terminate the agreement and move their services.
Jeff, maybe we can talk a little bit about what a cloud services agreement is and what it does for our clients.
A lot of people these days are acquiring services on a cloud-based model, meaning that their data either is processed in the cloud over the internet, or they're acquiring services through the cloud. And so there's other examples as well, such as platform as a service, where people are acquiring computing capability, where they may need a bigger server that they don't have in-house and they don't want to buy the infrastructure, but they can buy simply space on a bigger computer and administer it from afar. So there's many different models of services available, and they're many times referred to, like I said, platform as a service, software as a service, applications as a service, and it really depends on what you're trying to acquire.
Jeff, I imagine that data security is a big problem, or a big concern, I should say, for our clients. How do you manage that risk?
Absolutely. Data security is one of the top, if not the top concern, and has been very high visibility these days with major security breaches at some retailers and other institutions. And so data security is always at the forefront of our minds when we're reviewing and advising clients with respect to any cloud services agreement. We usually manage that through provisions that address specifics as to what the vendors are going to provide by way of security, infrastructure, what the vendor's obligations are. Many times the clients are working in a regulated space. For example, healthcare clients have to comply with HIPAA, financial services clients have to comply with Gramm-Leach-Bliley Act, and we address those specifically and head-on, making sure that the agreement is going to bind the vendor to meet the standards that are applicable in each instance. One other area that we run into a lot is cross-border transfers, where companies may not necessarily consider if there's data coming from the European Union or from Canada or other areas. Those are governed by different sets of laws, and so you have to have, in many times, enhanced security and privacy infrastructure to address the regulatory concerns in those other countries.
So how do you make sure that what you've bargained for you're getting from the cloud service agreement?
Vendors like to leave things very open-ended and not make many promises. And one thing we've seen a lot of lately is vendors incorporating terms from the web, which effectively means that they can change the agreement after you enter it. That all they have to do is post a new set of terms saying what the service is going to do, and as long as they comply with what they're saying, that's what it's going to do. So we always focus on making sure that the agreement objectively documents what the client's expectations are, whether that's incorporating a specification sheet that the vendor provides, binding the vendor to their written representations as to the functionality of the service, or just expressly stating what those expectations are in the agreement, one way or another, it's important to make sure that that's documented and the client's going to get exactly what they expect to get through the course of the agreement.
Now, Jeff, what happens when the relationship is over? Obviously, a lot of things that the client has is going to be in this cloud services. Is that something that is owned by the client, or is that something that's owned by the vendor?
Well, that's usually negotiated on a case-by-case basis. Generally, it's owned by the client. It's another very important piece of the puzzle in making sure that we're addressing the client's business needs in the agreement, and making sure that the client can move their business forward once the relationship is over. So we usually try and address the return of the data at the end of the agreement, and specifically, the timing of the return of that data, the format of the return of that data, because you want to get it back in a format that's usable for the client, so they don't have to go and pay data conversion fees or take additional steps afterwards. And in many instances, actual transition services where the vendor is obligated to help the client move along and transition either to in-house or to another vendor. But having the continuity for the business is always really important there.
All right, Jeff, I wanted to thank you very much for joining us.
Thank you, Rick.